Okay, so today we're going to look at the elements of an effective legal system. It's the first dot point for Unit 4, Outcome 2, and these elements are really important because in this whole area of study, you need to be able to assess how everything that you look at contributes to the elements of an effective legal system. So there's three elements that we look at: entitlement to a fair and unbiased hearing, effective access to dispute resolution mechanisms, and timely resolution of disputes. And there's a good acronym to learn them by. It's FAT, F-A-T, fair and unbiased, effective access, and timely resolution of disputes. Firstly, fair and unbiased hearing. Essentially, an effective legal system provides structures and procedures that facilitate a fair hearing or trial free from bias. So people should not be discriminated against by the legal system, and neither party in a case should be disadvantaged. A judge and jury should be impartial, and both sides should get a fair hearing. That's basically what our system is based around. Some aspects of the courts that assist a fair and unbiased hearing are the rules of evidence, in that hearsay and opinions are excluded, the rules of a procedure, because witnesses are questioned by both sides to bring out the truth, and both parties have an equal chance to present their case. We have the right to silence, that the accused in criminal cases is not obliged to say anything that might incriminate them. And we also have consistency in sentencing. The Sentencing Act of 1991 aims to increase consistency in sentencing by setting out guidelines for judges. We also have the jury system, where the accused is tried by his or her peers, which is fairer and unbiased, and the adversary system itself, where both sides should have an equal chance to win the case. In terms of effective access, we can say that all people should be aware of their right to take a matter to court, a tribunal, or ADR, and that all should have equal access to those bodies. Some aspects of the court system that assist effective access are the court hierarchy, because lower courts can hear cases quickly and cheaply, which frees up space for other cases to be heard, in particular for the higher courts to hear more complex cases. We also have specialist courts like the Curie Court, the Children's Court, or the Drug Court that provide access for special sections of our society. We have an appeal system whereby if people are dissatisfied with a decision or feel that it was an incorrect decision, they're able to appeal to a higher court. And we also have Legal Aid Victoria, which can provide legal assistance to people if they're unable to afford a lawyer. They can provide free legal advice. However, funding for Legal Aid Victoria is very limited. In terms of timely resolution of disputes, it's important that all people are able to achieve a resolution to their case quickly in order to ensure that the outcome is known, the dispute can be settled, and that the stress and the cost involved in going to court is reduced. The longer the case goes on, obviously the more stressed the person might be from not knowing the outcome, but also it increases the cost involved in terms of having to pay for a lawyer for longer, having to pay for court costs for longer, having to pay for a jury for longer. And that in turn can then reduce effective access. Delays can also reduce the effectiveness of witnesses because we're relying on their evidence in order to try the case. In terms of timely resolution, it's important that we balance off the desire to resolve the matter quickly with the need to give both parties enough time to prepare and prosecute their case to the best of their abilities. So you want to resolve the matter quickly to reduce stress, but not too quickly so that the outcome is perhaps incorrect or unfair. Some aspects of the court system that assist this, again, the court hierarchy. Again, lower courts can hear cases quickly and cheaply, and we also have directions hearings in civil cases, particularly that resolve issues so that they don't need to be discussed during trial, so they can save time at trial if possible. We also have committal hearings in criminal procedure that ensure that cases, if there's insufficient evidence, then they don't proceed to trial. And that's it.